Thank you. This is our case CV 230283, San Diego Gas versus Arizona Department of Revenue. Counsel, you ready? Please proceed.
Good morning. May it please the court. My name is Paul Mooney. I'm here with my partner Bart Wilhoit. We represent San Diego Gas and Electric Company. Mr. Acey from San Diego Gas, the tax director, is seated in the gallery behind me. The issue before you this morning, as restated by this court, is whether the Court of Appeals made a mistake in holding, after finding that the tax court correctly included the cost of removal as part of the accumulated provision for depreciation in determining the value under A.R.S. section 4214-154, whether it nonetheless went too far in vacating the tax court's judgment and decision regarding that full cash value. It is our position that the Court of Appeals did incorrectly hold that you cannot consider a so-called negative number, and by the way, I'll get to that in just a moment, in calculating a value under a statutory formula. That proposition, frankly, is absurd, because the very issue that gave rise to this litigation was whether or not the accumulated provision for depreciation was calculated correctly, which by definition is a negative number. In accounting,
depreciation. I want to ask you a question about that.
Sure.
What's your authority for using Rule 631, which was published in 2003, to interpret the terms and the application of terms in 141-54 when we're limited to what was in effect on January 1st, 1989?
Well, I'll answer your question twofold. First, the authority is A.R.S. section 4214-154.
Which limits us to what's in effect January 1st, 1989.
It limits the court to the version of the Uniform System of Accounts that was in effect on January 1, 1987. Interestingly, in the record below, if that had been the rule that was followed, rather than the Order 631 by the FERC, which was issued in 2003, then there would have been an even greater write-off for depreciation, because Order 631 modified that 1987 provision by removing asset retirement obligations from the accumulated provision for depreciation.
So you would agree with me then that the 2003 ruling changes what was in effect as of January 1st, 1989?
It does change it, but it only changes it to the extent of reducing the depreciation write-off, because prior to that, the depreciation write-off was even greater. So if what the concern of the Department of Revenue in this case is that we're deducting too much as depreciation, under the pre-Order 631 state of the record, we would have been deducting even more.
Well, and not to be too curt, but math is math.
I want
to know what the statute requires us to follow.
You're absolutely correct, and if we'd done that, first of all, we would have had to start accounting differently than the company accounts, because obviously the company is bound by the FERC.
Sure, and I get that distinction too. So the reference to what was filed on the Form 1, the record is what it is in that regard.
Agreed.
As I look at the statute, though, in trying to determine exactly how these different types of properties are valued and then how they're allocated, that paragraph F is sort of a blinking light, that we look at the terms and the application of the terms as they were in effect as of that date.
It's more than a blinking light, given the Salt River Project decision, which basically notes that the statute itself was amended subsequently to state that that is not only a guideline for interpreting the statute, it's mandatory.
Well, in 1989, under the FERC, the Uniform System of Accounts, could the accumulated depreciation include future cost of removal, or was cost of removal only to be included in the year of that removal?
No, cost of removal is always part of the accumulated provision for depreciation. Under the Uniform System of Accounts, pre-1989 and post-1989, the cost of removal, the accrual for the future cost of removal, is part of the accumulated provision for depreciation.
Where is that provided for? Because when I look at account 108, specifically paragraph B, it's at the time of retirement that you then book costs of the property retired and the cost of removal. There's no future in there.
Well, here's the problem. You're talking about an asset retirement obligation, which is in accounting parlance, different than the cost of removal reserve. Depreciation is always a reserve.
Right.
There's no such thing as depreciation. It's not an account that you can look and say, this is the depreciation. Depreciation is
you reserve it aside.
It's a construct of accounting that requires you.
Where's the authority at then to take into account that future cost of removal? However we describe the accounting process. Where's that authority pre-January 1st, 1989?
The accounting requirements of the FERC's uniform system of accounts have always existed. Prior
I get that, but can you point me to where? And I mean, I'm not, trying to play gotcha. I want to know, where can I go to look within the pre-1989 Uniform Statement of Accounts? Where's the provision that tells us that?
Well, first off, I'm not even sure you can look up the pre-1989 version.
We've got really good clerks.
Well, if you can find it, and I suspect you can find it in the Federal Register, I suspect that's where you would find the definitions for Account 108 and all the related provisions that relate to how you account for plant. Remember, in a nutshell, this is a formula that was adopted by the legislature really at the time to deal with the major issue in the state, which was the Palo Verde nuclear plant. The Palo Verde nuclear plant had billions and billions of dollars being spent to build it, but the Nuclear Regulatory Commission, until they certified it and authorized it to operate, that was all construction work in progress. With that construction work in progress, because of the way the accounting works, construction work in progress, although it will become plant when it goes into service, is not yet in service. And so for regulatory rate-making purposes, and these are rate-regulated entities that are subject to this formula, they can't earn a return on something that isn't in rate base. In recognition of that, and the fact that even though it took 12 or 15 years or whatever it was to build Palo Verde, the supposition was that for property tax purposes, those expenditures obviously had some value. And so the recognition by the legislature was, let's write a statute that deals with that reality.
Well, and then the reality changed in the late 90s. As you know, they then deregulated the electric generation part of the utilities.
Until they re-regulated it a year later.
But they did, and that was what then they can't value all of the components as an integrated whole because they were forced to sell off the generation. So it brings us to the 2003, and that's what I want to bring you back to. Sure. the issue before us, which is this current state of 154. I read it as simply giving value to the various components of the plant in service, the materials and supplies, the construction work in progress, and the environmental portion, regulatory portion. But it doesn't say how that's to be treated or sent to the counties. And I look at 157, which no one seemed to really focus on, as being that vehicle, which talks about, okay, you combine the values for plant and service and materials and supplies, and then you combine the cost. Then you do the proportion. Then you do the construction work in progress in situs, so wherever it's located. So why doesn't that answer our question as far as the formula for use after the valuation in 154?
Well, for one thing, 157 does not prescribe an allocation methodology. That's always been left to the discretion of the Department of Revenue. And the allocation methodology that's used for the so-called unitary properties in the state, railroads, pipelines, telecommunications, whatever, they differ. In some cases, they do it on a per mile or a per foot basis for where the property is located. In other cases, they look at a variety of economic factors. The point is, allocation, as long as it's reasonable, is upheld. 157 does not specify an allocation methodology that's binding.
But before that, though, before you get to the allocation, what it does, it seems to me, makes clear that you don't combine into what you were calling the summation method. You don't add it up to one value before it's allocated with whatever methodology you use for allocation. You don't arrive at one sum. It seems to be just the plant and service and material supplies, and then separately the whatever that construction work in progress, and then the 50%, and then separately the environmental.
Well, respectfully, I disagree. That's not how 154 is written.
Well, I'm talking 157. That's why.
I understand. 154 is the statute at issue here, which is how you value electric transmission property in Arizona, which is defined in 4214-154A as the valuation of all electric transmission.
Well, but
And it is-
counsel, I want to challenge you a bit on that, because the valuation of all electric transmission property, it doesn't say come up with a full cash value for all
No,
the
it
property.
says the valuation.
The valuation, right, and the valuation of the property. And then when you get down to B, and C, and D, and E,
Right.
it sets forth, and this is how you value this type of electric transmission property. 4 types, which correspond to the 4 different things that need to be allocated later on. They all sort of line up.
They're all electric transmission property. They're all property that's subject to this statute.
Correct.
This statute has separate designations for specific subcategories of how you value that. That's no different than what we do for pipelines. We value CWIP for pipelines at 85% of its value.
But the pipeline valuation is different, though, because there is a unitary view of it. And I guess what I'm pushing back on a bit, and feel free.
Sure.
This is the exchange. When I look at 154 as what the Vice Chief Justice was referring to, we've got a separate method of valuing each different type of property, whether it's the original plant and service cost, value of construction work, materials and supplies, and then value of environmental protection facilities. Each one of those is valued separately.
To arrive at a full cash value for all the property.
Where do you find that authority?
The first word in subsection A of 4214-154
Okay.
says
And then-
the valuation, and I might
Well,
add.
the
there's-
valuation, not the full cash value.
Oh, yes, but go back to the definition of full cash value. 4211.016 says full cash value means the value determined as prescribed by statute.
So why can't that be the value of plant and service under 154?
Because plant and service is merely one component of the total value of the electric transmission property at issue here. If we had environmental protection facilities, they would be included. If we had materials and supplies, they would be included. Those are the things which the legislature prescribed as the components that go into the calculation of the full cash value.
So what utility does the full cash value then serve in statute? Where is there any particular statutory reference to the full cash value for any purpose?
A.R.S. 4211.016, which defines full cash value as the value determined as prescribed by
Okay,
statute.
now my head's starting to spin. So even if we were to say, okay, you can sum up these different subcategories to come to a full cash value amount, what then? What is that full cash value amount used for?
That value is used as the basis for imposing what used to be primary and secondary, but which is now just all property tax rates combined.
Okay.
Because in the case of unitary properties, and full cash value and limited value are the same, so we don't have a Prop 117 issue to deal with these properties.
Okay, so I want to make sure I understand then, that you're saying that that full cash value then gets used by the state, by counties, by municipalities?
It's determined by the Department of Revenue by law under Title 42, Chapter 14. It is then allocated or apportioned to each of the counties in which the property is located.
And is that pursuant to 157?
It's pursuant to whatever methodology they adopt, because 157
But
doesn't.
the statute that does the allocation is 157. Okay, where in 157 is there any reference to the total full cash value as defined or as determined in 154A?
Well, respectfully, I disagree that 157 is an allocation statute. It is not. The apportionment of value that's done by the Department of Revenue is done by law prior to December 1st of each year, and they notify each of the counties in which any property is located that they have valued as to what those values are, and those values get placed on the roll.
And what statute does that?
It's in Title 42, Chapter, I have to look it up. I don't have it committed to memory.
But when you say that it's just up to them and 157 is not an allocation statute, at least construction work in process, it says determined shall be allocated among the various taxing jurisdictions on a situs basis separately from the unit value of the environmental protection facilities. So why isn't that exactly what it sounds like, which is an allocation at least of that, saying if it's located, I read that as if it's located in one particular county is going to get the full value of that CWIP in for its tax roll.
Respectfully, I don't agree with the premise of the question, but if you read 157 as an allocation statute, and you believe that it provides a separate allocation for construction work in progress from plant in service, that merely is an allocation issue. That is, where does the value get allocated? It doesn't change the overall value that's at issue here, which is, as the Court of Appeals held, correctly determined in accordance with the method prescribed in 4214-154, which is these individual components added together or subtracted from each other to arrive at a total value, which in this case is a positive value.
Well, here's my concern with that, and you can tell me what's wrong with that. The way I read C, what I just read, it seems like the legislature is wanting to be on a particular county's tax roll the full value of the construction work in process value. If that's so, then you could not use a negative value of the plant and service value to offset that, because it would then shortchange that county on the value and what it's able to tax. And so that's what I'm concerned with, what actually the trial court did, pardon me, in offsetting the construction work in process by the negative number. Perhaps you could do it with the materials and the supplies, but I didn't see it for that.
First of all, there is no negative number.
Well, okay.
The only way there's a negative number...
Humor me and forget this case. Say just in any case, if can you have some kind of an offset?
Well, first of all, with a regulated utility, you're not going to have a negative number, because no matter what happens, they can only earn on their rate base. So they're never going to let their rate base shrink to below zero. They're always going to have a rate base that's a positive number, because if they don't, they're not going to be able to earn a return. They're monopolies. And so their business decision-making is they have to invest at least an amount equivalent to their depreciation write-off every year, or their rate base shrinks. That's never going to happen. So it's a hypothetical. It didn't happen in this case, and it's never going to happen under this statute.
Okay, then let me change the question then. Sorry. Forget the negative number. Why would it be under 157C if all of the construction work in process value is to go to the county in which it is located? It sounds like what you're saying is you just add up all of the components to reach one figure, and then I guess the ADOR or the county assessor, I'm not sure which, I guess ADOR can allocate it to however they want, which might still result in less than that full value for the construction work in process being allocated to a particular county.
Here's where I think the fundamental disconnect occurs. Construction work in progress is plant. It's plant that's not yet in service. It's a timing issue. That same construction work in progress that's at issue in this case goes on the tax roll the next year as plant in service at double the value. It's all plant. It's all part of the electric transmission property that's at issue here. It's not something separate or distinct. It's not.
Is it allocated to the county the same way?
In theory, the Department of Revenue can allocate the total value in whatever manner they want.
Not if she's reading the statute correctly.
Well, understood. I understand what she's reading from 157. First of all, no party has argued 157 in this case, including the Department of Revenue. And the issue of allocation was never an issue in this case. But my answer to your question is you can determine a full cash value that is comprised in part of construction work in progress and plant that's already in service, and you can allocate that fairly to the different counties. If the counties don't feel like it's been fairly apportioned, the counties have a mechanism for basically challenging that.
What I think I hear you saying is that if it's plant in service, or if it's, you think you called it CWIP, I would have said CWIP, it's allocated the same way.
It should be, in my opinion. I'm going to save what little bit of time I have left. Thanks.
May it please the court, Jerry Freeze, appearing on behalf of the Department of Revenue, Maricopa County, and Yuma County. The subject statute is plainly not a summation valuation statute, given that each statutorily identified component has a separate, independent, and unrelated valuation method.
So to address the last question, how is it allocated?
Well, it's allocated based upon location primarily. If you have $1 billion of plant in Maricopa County for a transmission line and $500,000 in Canal County.
Does it matter whether it's construction work in progress or actual plant value? Is it allocated?
No, I didn't. No, but it's allocated dependent upon where it is, and so obviously
But it's allocated the same way.
It's allocated the same way, exactly. So if you have 100 miles of pipeline in Navajo County and 5 miles in whatever other counties up there, Apache County, $100 million, the proportionate amount will be allocated to the 100-mile county. That's the way it works. Obviously, that's the way it works.
Council, can we focus on?
Wasn't obvious to me.
Yeah.
Well,
Let's focus on 157 then. And the reason why 157 is important is because if it allocates the values separately, then that's an indication to me that the values are supposed to be separately calculated.
they are separate.
And they aren't supposed to be aggregated. So in the instance of, and I'll go with CWIP as well, 151.7C, where it talks about allocated among the various taxing jurisdictions on a situs basis. I take from the answer you were just giving that, yeah, you value the CWIP based on where it is for allocating it to the tax rules for that taxing jurisdiction.
Sure.
And if that's true, then I want to go back to a question that I asked opposing counsel. What use is there for a total full cash value under Arizona statutes?
There is no use. It's an argument that they make. We like to add them all up and come up with a negative number.
I get that, and that's what I'm trying to
Right,
distinguish.
there's no use. There's no use.
So ADOR does not use a total summed up full cash value for the determination of any tax in any statute.
Well, I don't think that's true. There are statutes that determine a value, I think, for pipeline and whatever.
Right, well, yeah, and it does, and
Right.
there are other provisions. So
Right,
at least with
right.
respect to electricity transmission, then, a total full cash value might be nice for a ledger entry for maybe you have to report that to FERC, I don't know.
Sure, it's an argument. It's something they contrived. It looks good on paper. You have to have that put down on paper to give their argument any credence. It has no credence in the statute. The valuation statute values these independent components separately, and they're allocated separately.
So then I want to understand the department's position when it comes to the potential for there to be a negative value for plant and service. Certainly at the time of retirement, when you add in cost of removal and depreciation, you conceivably could get to a negative number. But under 141.54B, in valuing original plant and service, that would have nothing to do with 141.54C valuing CWIP, and isn't even referenced in the allocation statute for where that money would go. So am I correct then that the department's ultimate concern about effect on CWIP is that if we read these statutes as we've been discussing them, it doesn't matter whether the value of a plant and service is positive or negative, it's not going to affect CWIP. Is that a fair
Correct.
statement?
Correct. It shouldn't be a negative value, but we've lost that. It doesn't affect CWIP. If something were to affect CWIP, the legislature would have to do that. It's the legislature's call to attribute depreciation to a cost. So they've done that with respect to plant. They've done that with respect to flight property in a different statute. There are many statutes where the legislature has said, start with the cost, subtract depreciation. And they haven't done that with CWIP. It's a simple statute. Take a number, divide it by 2, that's the value. And that's the value that should be sent to Yuma County. It's not sent to Pima County because it's not in Pima County, it's in Yuma County. So that's why they do that. So
Maybe I didn't understand the colloquy between you and Justice Montgomery. Did I understand you to say that the term full cash value has no particular use?
no, it does. It's statutorily, Mr. Mooney's correct, 4211.006 defines full cash value, but the issue is full cash value of what? And so the full cash value of a house, that's one number. That's one number. You can't pick it apart, and that's what the Transamerica case talks about. You can't appeal the land. You can't appeal the improvements. You can't say, well, I have a bad roof.
So what do you report to the counties when you allocate this? Do you say the full cash value of San Diego Gas and Electric's property in the state of Arizona is X? Or do you give them various accounts? Here's what the CWIP is, and here's what the...
That's what the department does. And
Does what? Which of those things does it do?
Well, the department is concerned about valuing property. The department has no issue in doing an aggregate number and doing it for what purpose. There's no purpose to that. The issue is what's the value of CWIP, what's the value of environmental protection property?
Well, my question of you is, when you send the letter off to Yuma County saying, here's how much you get to tax these people, does it have a list of numbers, or does it say, here's what San Diego Gas and Electric's full cash value is?
What it will send that to, say, Yuma County, so it'll create a separate account number for CWIP relative to plant. The value of CWIP in this particular taxing jurisdiction is $3.65 million. It'll send a letter to Maricopa County. You have no CWIP.
So it breaks them out separately?
It does. It has to, right. It does.
And so when the county sends its tax bill to San Diego Gas and Electric, does it say the full cash value of your property is X? Or does it say you owe us this much for this and you owe us this much for CWIP?
Well, the department sends out the valuation notices. I don't know how precisely it works in terms. So they send the valuation notices to the company. The county treasurer they'll get the same values. They will take the tax rate. They'll apply the tax rate to the full cash value. They will send out the bill. But it's done separately. The department has no interest, and there's no statutory reason to lump them all in one number, except to feel good, to do something. It's contrived. It's contrived. It has nothing to do with what the Department of Revenue does.
So when you do the CWIP, getting back to what Mr. Mooney's point, that is simply part of the plan. It's just not in operation yet. And of course, this is only about taxing operational equipment and such. So it says the CWIP is in situs. In Yuma County, for example, some kind of transmission work in progress, would it only be then allocated entirely to Yuma County in the year it's still in progress, and then say the next year it becomes in operation? Is it then all given again to Yuma County, or is it, because it's part of a whole, is it allocated with Maricopa and Yuma?
Well, the plant will be valued as part of a whole in the following year, and then it will be a portion dependent upon its location. And so, again, if you have 100 miles of pipeline in Yuba County or 100 miles of transmission line and 10 miles in Maricopa County, the value of the apportionment will be that number, that ratio. And that's obvious. The county's not going to permit property taxes due going to another county based upon property located in its county. So I think that's intuitive, and that's what the 42-157 gets to. We didn't brief it. Mr. Mooney says it's not an allocation statute. It is an allocation statute. The word allocation appears at least once, if not more times. And so it's not a summation statute, it's subject property. For a summation statute, I would turn the page. So the subject statute is 42-14-154. Turn the page to 42-14-155. It talks about the valuation of environmental properties, renewable energy properties. And there's a formula. It starts with original cost, less the value of investment tax credits, less straight line depreciation, times 20%. That's a summation method. You have functions in between something. You add and you subtract and you multiply, whatever it might be. And we don't have that in the subject property. Again, the legislature has defined separate statutory components of the subject property, separate, unrelated, independent statutory valuation methods.
So looking at ADOR's manual for centrally valued properties on page 6, it sure seems, if I were just reading this and as a taxpayer trying to figure out what you're doing here, it seems like the point is to reach a full cash value. There's all of these separate components, and at the end it's equals full cash value. And then the manual notes this procedure is fully described in A.R.S. 42-14154. Nonetheless, the full cash value, you could just take that out and the manual would be no different because it's really pointless. Is that?
Well, I think it's a very generic point. I mean, it doesn't abrogate what's in the statute. It's just a very generic description. We determine full cash value. And then you jump into the statute and it says, well, there are actually multiple full cash values dependent upon the type of property and dependent upon the statutory formula. So some components of property valued by the department, sometimes the land is valued by standard methods and techniques, sometimes it's valued by, again, the cost method. It depends. It depends. And here, with renewable energy, the property, the case I just talked about, they just value renewable energy property. All renewable energy property shall be valued under that summation formula. They have broken it apart, again, in the subject property, as we all know. And so you have different full cash values determined differently. They're not related to each other in any way, shape, or form. And as pointed out, 42157C makes that point. The question, one question that came up in my mind is, what if we had no CWIP in this case? What if we had just plant and plant had a negative value? What do we do with that? What do we do with it? Do we carry it forward in the future year? Do we make the county pay the company taxes? What do we do if we have nothing to
Well, how do you respond to Mr. Mooney's point that that could never happen because that's the value establishes the rate base? You have to have a positive value for the rate base.
Well, it could happen. Assume they had no CWIP. What if they had no CWIP in the subject year? You'd have a negative value. That's all you'd have, a negative value for plant of $2.4 million.
Well, if we follow the statutes, and actually I wanted to ask you that question. If we were to follow the statutes, wouldn't you, in making that determination each year, just at the end of a year in which there might be a negative number, when you go to the allocation statute and you do the math, you wind up with nothing to allocate?
Well, I think there'd be a negative value, so I think that's correct. But then the issue is, what do you do with the excess negative $0.24 million? And it's really kind of an academic issue. But the idea that you have to apply it against something. What if there's nothing to apply it against? Then what do you do?
Well, I would ask you as ADOR, what do you do?
Well, I don't know. It's unprecedented. In the history of ad valorem tax.
So Mr. Mooney's right, it's never going to happen?
That,
Since it never has?
well, it could have happened in this case. It could have happened if they had no CWIP. It could have happened. The fact that they had CWIP kept it from going completely negative. So the fact that we have a negative value is unprecedented. It's never happened in the world in the history of ad valorem taxation. Negative values have never been legislated. No legislature, no parliament has ever done it.
Well,
and you have to ask, why would they do it? It makes no sense.
At least for the academic discussion, at least with respect to the valuation at 14154B, unlike, just for example, the valuation that's done for telecommunications, I think it's maybe 141,433 or 43, regardless of the actual number, there are two provisions in there which state that the valuation following depreciation can never get below a certain amount.
Correct.
Okay, we don't have that provision here. So wouldn't we then say, well, at least conceptually, and the example I gave was if we go back to the Uniform Statement of Accounts looking at the time of retirement, applying depreciation and cost of removal as it's discussed therein. If the cost of removal, for whatever reason, exceeded the value of the plant and service at that point in time following all the depreciation, conceivably that could be negative, couldn't it?
Well, I think that's what we have here. We have depreciation, accumulated monies, core monies associated with future removal costs being used to devalue.
Well, and I don't want to get into that right now, because
Right.
that then invokes.
It's already been
631.
decided,
Yeah.
correct.
But I'm just saying, though, conceptually, if you got to the point in time at retirement, following depreciation over time, and you've got the cost of removal, which you then know at that point in time too, couldn't that number conceivably be negative?
No, I'm not an accountant, but I will say at the time of retirement, the department is no longer valuing the property. It's not plant in operation, so we don't value it. We only value plant in operation. We only value.
But if it
CWIP.
was in operation for part of the year?
Yeah, our position from the beginning is the only lawful depreciation is accumulated straight line depreciation relating to plant costs. I don't know how to address that. I'm not an accountant. Could it go negative? I guess it could, because it's gone negative here. And so I guess it could.
Well, isn't that what the legislature specifically legislated in this context? It says you determine the original plant and service cost, you subtract out the accumulated depreciation. It doesn't say anything about it can't be negative.
Sure, it says accumulated straight line depreciation.
It doesn't say anything about straight line. It says related to accumulated provision for depreciation.
Right, and depreciation is defined as straight line depreciation over the useful life of the property. And so I would explain it the following way. Give an example. Forget about core monies. Okay, let's say we have $50 million in plant in this state, and that plant has $40 million in accumulated depreciation. Okay, and they report that to FERC. They report the 50 and the 40. But they don't report 50 to the department. They only report 10. They report 10 million in plant costs, but they report 40 million in accumulated depreciation. And that's lawful depreciation because it's on FERC's books. But the problem is not all of it relates to, not all of it is accumulated straight line depreciation of the $10 million in plant costs. So even though it's lawful depreciation under FERC, the only lawful depreciation of that 40 million is that relates to the $10 million in plant costs. So that's our case. That was our case below. And core monies, just like the 40 million are not accumulated straight line depreciation, core monies inarguably are not accumulated straight line depreciation of plant costs. And that was our case below. And so could it go negative? I guess it can. I guess it can.
Did ADOR be salt? Did the Court of Appeals just simply misinterpret 154 with respect to summation?
Well, I think the Court of Appeals got it right. And they said they're separate, and we're not going to take the excess depreciation and apply it to CWIP. And so that's what they filed a petition for review on. I think the Court of Appeals got it right. They're wholly independent. They stand independent. And again, if they wanted to include additional depreciation to be applied to CWIP, they would have done it. They did it to plant. They've done it to flight property. They've done it multiple times in Title 42, and they didn't do it here. And again, what their case in chief is, well, we want to get the advantage of that. We should get the advantage of that as a matter of law. And even though the legislature didn't give it to us, we'd like the court to give it to us. And I don't think the court can do that. I think that's up to the legislature. They haven't done it. At the end of the day, San Diego has gotten a great bargain. They paid no taxes in Maricopa County whatsoever in tax year 2020. They're going to pay negligible taxes in Yuma County based on the CWIP only. We think it should be 3.6 billion or 3.3, whatever it might be. That's what the statute says. It's very simple. It's a fifth grade math formula. Take a number, divide it by 2. So I think that's all I have.
Thank you, Counsel.
One of the advantages to being able to sit down and reflect on the court's questions is something's been missed here by everybody. My client can only appeal the full cash value of its property. It's the only thing by law that my client can bring to the courts in Arizona. That's what they did. They filed a tax appeal challenging the full cash value of their property for tax year 20. That's it. I can't challenge the value of my CWIP separately. I can't challenge the value of my EPF separately. I can only challenge the value determined under 4214-154. That's what I did. Respectfully, construing the plain language of this statute, you can read it as a whole as determining the full cash value of my client's property in Arizona. That's what it is, part of which is CWIP. CWIP is nothing more than plant that's not yet in service, and it's valued at a discount. It gets doubled the next year, and it did get doubled the next year. And this hypothetical problem that keeps being alluded to that is never going to happen with a regulated utility didn't happen in this case and wouldn't happen. And wouldn't happen the next year because that value goes back on at $7.8 million of new plant and service.
Thank you, Mr. Moore.
Thank you.
Counsel, thank you for the supplemental briefing and the oral arguments in this matter. The case is now at issue. An opinion will issue in due course. The court is adjourned for the day.